Good afternoon, and today I'd like to talk with you about what happens now if you've been placed at max medical improvement. If you don't remember what that means, just look at some of our earlier videos where we talk about MMI and what MMI means and what does that mean. What does it mean? So a lot of times doctors will say, okay, your case is closed, and that's not the case. Your case is not closed. It just means they're shutting down their file for you maybe at that moment, okay? So as we talked about, MMI just means it's the point in time where the doctor, okay? And at that point, you may still need maintenance care. It's called treatment to get, not to get better, but treatment to maintain your condition. If your doctor recommends maintenance care, then you make sure that you do it. Make sure that you make it available and make sure you take advantage of it, okay? So if the doctor prescribes prescriptions, you should keep doing that. If the doctor's recommending gym memberships, you should do that. If there's some sort of home exercise therapy, you should do that. Physical therapy, make sure you're continuing with the maintenance medications, because if you let time go by without getting it, the more time that passes, eventually the insurance company is going to say you don't need it. And so therefore, we're not going to provide it anymore. Number two, unfortunately, you might still be getting, you might be off work and you might be getting some workers' compensation benefits, but until you get what's called a final admission of liability, you're not able to apply for unemployment. But the moment that you get that final admission of liability, you should apply for unemployment. Now, many times when people are placed at max medical improvement by the treating doctor, there's a question about, are you capable of working? Does your employer have to accommodate you? What happens if you can't do your old job, etc.? So let's talk about those situations. If you're able to do your job and you are in fact working when you're placed at maximum medical improvement and you're working your real job, okay, not a make work light duty position, you're doing your regular job and able to do it fine, no worries. Keep working, keep doing it. If you want to change jobs, maybe you can. You should talk with an attorney before you do that, but not a problem. What happens if you're working but you're kind of really being accommodated? You're not doing all the job, maybe you're only doing a part of it, or maybe they even have you in a position that has nothing that nobody's doing. Like, for example, at the meat packing plant here, they'll have people sitting in the cafeteria wiping tables. They don't employ anybody to do that full time, okay? You need to have a very serious look at and talk with your employer to see, are there any positions, real positions, that you can do either with or without what's called accommodations, reasonable accommodations. So let me give you an example. Let's suppose part of your job is to put books away in a bookcase like this, but the book's case is pretty high and you've got restrictions that you can't reach overhead because of a shoulder injury. What's a reasonable accommodation? It's probably not making another employee do it. It's probably not telling the employer they can't put their books so high. But if we got you a step stool and you were able to step up on that stool so you could put the book back without raising your arm above your shoulder, that would be considered a reasonable accommodation. So if you are working when you're placed at maximum medical improvement but you're doing a really modified light duty accommodation job, start having a really good serious conversation with your employer about whether or not you can stay in that position, whether there are other open positions that you can do, or if you think you can go back and do your old job, go do it, okay? What happens now if you're off work completely, your employer hasn't been able to accommodate you, now you've got restrictions, you've been placed at maximum medical improvement, and you've been told, hey, your wage loss is going to end pretty soon, what can you do? Well, first thing I always recommend to my clients is, again, talk with the employer, see if there's any positions that are open available that you are capable of doing with or without reasonable accommodation under the permanent restrictions the doctor gave you. Maybe you don't agree with permanent restrictions. Maybe the doctor says, oh no, I don't think you should lift more than 15 pounds, but you know you can lift 25 pounds. And if you can lift 25 pounds, you can do your regular job. Then you should talk with the doctor about, hey doctor, could you send me for a test to see how much I can safely lift? Because I think I can lift more. I think I can do more. Okay, and then you can get your restrictions reduced so that you are able to do the regular job, if that is in fact what your capabilities are. Okay, and if you can't go back to your old job, but you've got restrictions, you might want to look and see what additional open jobs your employer has, and if they've got something great, apply for it. And if they don't have anything, then you're going to need to start looking seriously at finding other employment. And that can be scary, and that can be daunting, particularly if you're injured, particularly if you're no longer able to do the kinds of work that you can do. And the bad news is workers' compensation is extraordinarily poorly equipped to help compensate and keep people afloat for those times of periods. There's no benefit, for example, for vocational rehabilitation. And I can't get my clients wage loss after MMI if they're capable of doing some other kind of employment, even if it's a really light job, part-time, temporary, minimum wage job, okay? And then obviously you're going to apply for unemployment once the final mission comes through. But those are the folks that I most worry about, because they're really needing a lot of assistance. They're needing to rethink, retool, retrain, etc. That's where we come in, because what we're going to do once the final admission of liability comes in, we bring in our client, we have a face-to-face discussion with them, and we decide what benefits we agree with, which ones we don't, and we come up with an action plan to fight for either more treatment, more impairment, more benefits, or all of the above, depending on the case. That's why it's so important, if you or someone you know is injured on the job, that you have access to an attorney who will guide you, advise you, and help you get the most. After all, the insurance companies, they already have their attorneys that are helping them pay injured workers the least amount possible. Our system only works if both sides have somebody there helping them who knows what they're doing. Kaplan Morrell, we've been helping injured workers since 1997, and some of us have been practicing law a little bit longer even than that. We would love to be able to help you. As always, our consultations are free, they're confidential, and we can let you know whether or not we can help you. Again, thanks for spending part of your afternoon with me, and I certainly hope you have a great, happy weekend. Bye.